Today we're here on a modification that was filed back on May 6th of this year, Your Honor. In that, uh, the state is seeking to do a modification based off of minimum wage, as we have limited income information, and we're mom is in agreement that she's going to be carrying dental insurance through her employer at the cost of $20.35 per month.
I'm sorry, I
And
couldn't understand you.
I'm sorry.
D-
Mom is in agreement that she'll be carrying the dental insurance for the child through her employer at a cost of $20.35 per month. Mom
Okay.
is in agreement to continue carrying the child on a government health through a government health plan, wherein dad will reimburse the state $50 per month.
50.
Yes, $50.
Okay.
And mom is not in agreement to the calculated child support of $142, and I'll get testimony as to that.
Okay.
And ma'am, if you can please state your name for the record.
Kimberly Neal.
And did you hear the parts that you agreed to that I renditioned to the court or say to the court?
Yes, sir.
And are you in agreement to those portions?
Yes.
Okay. And ma'am, if you can, you're in, and as I said, you're not in agreement to the calculated child support of $142. Um, are you aware if Mr. Gaines is employed?
I believe he does something
Mm.
else, whatever you guys have on file. Like I said, I was
Oh,
aware that he,
okay.
go ahead.
And are you aware of his income from whatever source of employment you believe he has?
From yes, when he verbally told me himself,
Okay. And what was the income and what was the income he told you?
that he get pays anywhere from 18 to $2,000 per load.
Okay. And how often is that?
I would say every load between every drop off depends on how his loads are scheduled.
Okay. And when was it that he told you that information?
This was back in June.
Okay. And have you had any recent conversations to the fact that he's not dropping any load or not doing any transportation or doing any truck driving?
No, because he kinds to keep that away from me, so we won't be at this point where we are today.
Okay. And you and I discussed the limited information regarding income that the state has. Is that correct?
Correct.
And that we would be using minimum wage to calculate his support. Is that correct?
Correct.
And and how many children does Mr. Gaines have to your knowledge?
Um, to my knowledge, again, maybe 7 or 8 that I know of.
Okay. And because of the hesitation, we went with seven in our calculations. Is that correct?
Yeah.
Okay. And I told you that we came up to an amount of $142, given the fact that he has those other children. Is that correct? What do you believe child support should be set to, if at
I
based off
just
of
think
what?
it should be a more of amount because money is 10 now. She just turned 10 May 9th.
Okay.
She
Okay,
has
mom. So what do you have? What information do you have or what evidence do you have to show me what he's making? Because I don't have anything. The Attorney General's office doesn't have any information about what he's
okay.
making.
Well, as again, this is what he tells me verbally. Again, he doesn't he tries to not tell me this information.
Okay,
Again,
so do you know what company it was he was working for, or was he self?
I think this is a contract that he has himself.
Okay, and
So an independent contract through a broker.
okay, and so do you happen to know who he gets his contracts through, or no?
Again, no, me and Emmanuel don't speak at all.
Okay.
Like I told him, we haven't spoken over 60 days.
Okay. And so, without any information about what he's making, I've got nothing to base the child support on other than minimum wage because it sounds like he is capable of making at least minimum wage. Mom, if you were to find out information in the future, if the Attorney General's office gets information about where he's working, I would anticipate that they would file again. And if you come up with any information, you can always give that to them and they may file again. But based on what I've got before me right now, I am going to enter a default order against Dad ordering him to reimburse mother for the dental insurance in the amount of.
During the hearing, the mother explains that she and the father currently use a police station for child pickup and drop-off because of his violent past. The judge questions why the father is not allowed near her home, and then checks the previous court order. The judge discovers that the old order specifically lists the mother's home as the pickup and drop-off location, creating an immediate conflict between the existing order and the arrangement the parents are currently following.
$20.35 beginning September 1st.
Okay.
Ordering dad to reimburse the state $50 a month beginning September 1st, and ordering him to pay child support based on minimum wage of $142 a month beginning September 1st. Dad to pay court costs within 1 year if billed by Collin County. And like I said, Mom, if you get additional information or find out where he's working, and you can reach out to the Attorney General's office, but I would anticipate also if they come across something that shows an employer that they may file again themselves. Okay? Ma'am, I'm going to ask Mr. Hutton to draft up this order and send it to me. Once I sign it, the AG's office will send you a copy. Okay?
Okay, and can we also make sure Attorney General's office that my address is not included on none of these documents? That if he gets a copy?
Oh, he would get a copy.
I know, but I don't want my address included on any of those copies.
Okay, so give me just a minute here.
It should already be in you guys' file that my address doesn't supposed to be on any.
I'm not the Attorney General, ma'am.
I understand that, ma'am. I'm speaking to them.
Okay, well, hold on. Let's see. Give me just a second, Mom. I'm checking the prior order. Ma'am, the prior order's got all of your contact information in it.
But it's always removed.
Stop. Mom, and it specifically orders that you are required to notify the parties if this information changes. That was in the 2019 order.
It's been that way. There's a form that the Attorney General office send, and it
right, but that doesn't have anything to do with the court
address. And I just signed that paper again with the modification in May.
Okay, but that doesn't have anything to do with
that information.
Give me just a second here. Let me just make sure. I think I was looking at the wrong thing. I'm going to check one other place just to see. I had the wrong piece of paper pulled up, Mom. Give me just a minute. Yeah, here it is. It looks like he was in prison in the 2019 order. No non-disclosure. All of Mom's information is included in this order, in the 2019 order.
What 2019 order? You mean 2017? That's the last time we had an order.
No, there was another order after that in 2019.
September 2019.
In addition, in the 2017 order, it has all Mom's information in it also.
It should not be, because I requested, because I have valid history in our past, so it shouldn't be at all, ever.
Mom, why was that? Go ahead, counsel.
I was going to ask if you wanted me to get testimony regarding the non-disclosure issue, or
the problem is she's got a court order that specifically says she's got to. Let me look and see what it's got in the original order regarding. The original order specifically has pick up and drop off at mom's home. There's an order from
We don't
when he was
even do
in
that
prison.
anymore. Yeah, because our pickup and drop off location is literally what we chose, which is the Louisville police station, because again, his violent past. So that's what we currently do when he gets her.
Okay, Mom, that's not what I'm talking about. Counsel, or Mom, are there any provisions regarding Dad's
The judge explains that the existing custody order cannot simply be changed during this hearing because the proper request was not filed. The attorney agrees that the underlying pleading needs to be amended to address the police station exchange and other issues. After discussing the situation, the state decides to dismiss its current case, telling the mother that she can continue working with her custody attorney and address the remaining issues through a separate modification case.
release from prison or anything? Does he have anything saying that he can't come near you?
No, this is what we verbally agreed on. Because the order just basically states the pickup and drop off is anywhere. It really doesn't even have to be my home, because he's not allowed at my home. He's not allowed at my home.
So why is he not allowed at your home?
Because our valid past. We have
do you have a court order?
No, but that's what we agreed on. I don't have a court order, but Emmanuel is not allowed to come near me. And we don't meet up at my home. He's never picked her up at my home, even when that court order was originally in 17 and 19.
So, Mr. Hutton, what's the state wanting to do today?
Your Honor, given the facts and circumstances in this case, and given that based off of the statements of Mom, that it would seem that either I don't think we have it in our pleading. Yeah, there is a request to determine the disclosure of the address, and so if we can get a little testimony as to what the
Counsel, there's already a prior order that specifically has information that you would need to modify. You didn't plead to modify that underlying order that specifically says Mom has to give the address and also says pick up and drop offs at Mom's home. If you're trying to modify that underlying order, you got to plead for it.
So can we change that to it to be at the police station at Louisville, the pickup and drop off location?
That sounds like maybe that's what needs to be done. I don't know, but no, I can't do that
put that
today.
in the order.
I can't do that today. That hasn't been filed for.
Yeah.
Okay, we can file for it.
Well, given the circumstances, Your Honor, I think it'd be best to take leave and amend the underlying pleading to make that request.
Okay, so Mom, we're not gonna do this order today so that they can see what we need to do to get and counsel. I don't know anything about Dad's incarceration, if it had anything to do with Mom or not, so that might also help the situation. But I don't know. It could change. It may not change anything. So, Mom, we're going to just step back here, like Mr. Hutton said, and so that they can look at what they might need to do to amend this. Okay. I don't know if they're going to be able to help you do what it is you want, but let them look at it. Okay.
I'll just make sure when I go to court with my attorney that it's already submitted with the court child support order.
You got an attorney? Wait.
Yeah, we do.
Attorney at the custody. Yeah.
Because it's custody part. So it won't have anything to do, I guess, with you guys' part. But I am working with an attorney on the custody part of this particular section.
With this gentleman?
No, with just a court order, because I want to modify that court order. And the Attorney General office doesn't assist with that.
Okay, so you've got an attorney you're talking to about modifying the order?
Correct, of the custody agreement, correct.
Okay, so Mr. Hutton, does the state want to reset, or is the state going to dismiss their matter and let Mom go forward on her matter?
I believe all issues can be addressed in that modification that Mom would be seeking through, with the custody. She can also address the support issue. And that way she can have an order that before the singular court regarding all issues at hand. I don't believe there's a setting right now, so we couldn't necessarily refer it, or we wouldn't want to refer it because there seem to be other things going on. So at this time, Your Honor, we're going to go ahead and non-suit this and then have them go forward on that matter to address all issues.
be best for you. Just keep working with that attorney on the modification, and then they'll take care of everything. And then that way we don't have to
But
worry
that's
about
not what I'm
disclosing.
paying him for, because like he just told me not to cut you off by any means. That's strictly for the agreement.
Okay.
So yeah.
Okay. So the state's dismissing their matter. Okay. They may file again, but at this time they're going to dismiss their matter. So you're
Why
free to
would they
go for
dismiss the
today.
matter?
You can talk to the Attorney General's office. You can contact them directly if you want to speak with them more, but they're going to dismiss their case. So thank you, ma'am. Do you swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth?
Yes.
Yeah.
Thank you both. You put your hands down. Okay, Mr. Williams, where are we on this one?
Yes, Your Honor. We're here on a suit affecting the parent-child relationship. We have a full agreement aside from the. I need to take additional testimony on court costs, but aside from that, it's fully agreed. At this time, I'd like to read that agreement into the record for the court.
Go ahead.
Parties are in agreement for Mr. Shelley to be established as the father of the child in today's case via a valid.
In the next case, the parents have reached an agreement covering custody, child support, and insurance. The father agrees to pay the court costs, which could be several $100s. After the agreement is accepted, however, the father raises another important issue. He tells the judge that he took the entire week off work so he could spend vacation time with his child, but his visitation was denied, and he asks whether he can pick up the child and keep him through the weekend.
Validly executed acknowledgement of paternity signed at or around the time of the birth of the child. Parties are in agreement for it to be a joint in a joint managed conservatorship with one another. Parties are in agreement for a mom to be named primary with a geographic restriction to Collin and contiguous county so long as dad lives in Collin or contiguous county. Parties are in agreement for a standard possession order for parties that reside 50 miles apart away from one another. Parties are in agreement for there to be no retro today, Your Honor. Parties are in agreement for father to continue to carry the health insurance at a cost of $65 per month. Parties are in agreement for dad to continue to carry the dental insurance for the child at a actual cost of $11 per month. Parties are in agreement for child support to be set based on a gross monthly income of $8,033.30 for child support to be set today at $1,262. And I can't remember if I said this or not, but parties are in agreement for no retro, just to confirm. That is the extent of the.
You've got to slow down.
Yes, Your Honor.
Go back to after the child support.
I'm not sure if I said this before, but parties agree for no retro in this case as well, Your Honor. My apologies. That is the extent of the agreement. At this time, I'd like to call the parties to confirm that agreement, Your Honor.
Okay, go ahead.
At this time, I'd like to call the father. Sir, can I get you to state your full name for the record?
Charles Wayne Shelley Jr.
Thank you so much, Mr. Shelley. Mr. Shelley, did you hear the agreements I previously read out into the record?
Yes.
Are those still the agreements between yourself and the mother in today's case?
Yes.
Are you asking the court to accept those agreements?
Yes.
And do you believe they're in the best interest of your child?
Yes.
Now, I have one additional question for you, sir, and I apologize for not bringing this up to you sooner, sir, but court costs are associated with this case. As the non-custodial parent, you are typically the person to assess these fees in the case. This is not a part of child support. This is owed to the clerk itself. Would you be in agreement to cover court costs for today's session?
Yeah. Yeah.
Father's in agreement to pay court
How
costs.
much is it? How much is it?
It could be anywhere from $300 to $500, but it's not a part of your child support, and it's if billed within 1 year. If judge rules it that way, it's only if you get a bill within 1 year.
Okay.
So I have your agreement, sir.
Yeah.
Thank you, sir. At this time, I'd like to pass this witness and call the mother, Your Honor. Ma'am, can I get you to state your full name for the record?
Leslie Denise Rose.
Thank you, Ms. Rose. Did you hear the agreements I previously read out into the record?
Yes.
Are those still the agreements between yourself and the father in today's case?
Yes.
Do you believe they're in the best interest of your child?
Yes.
And are you asking the court to accept those agreements?
Yes.
And the father just recently agreed to cover court costs for today's session. This is a kind of silly question, but are you in agreement for father to carry court costs for today's session?
Yes.
Thank you. I'd like to pass this witness at this time as well, Your Honor.
James, do you have any information that would lead you to believe that Mr. Shelley reached out to the Attorney General's office for assistance?
Well, Your Honor, Mr. Shelley was already obligated to pay under a temporary order, and he was.
No. For assistance to start this case.
Oh no, Your Honor. It wasn't under his bequest. No, Your Honor.
Okay. Mom and Dad, I'm going to accept and approve your agreement I will order that dad pay court costs if billed by Collin County. If he is billed, he has a year to pay those. Okay.
Okay.
I'll ask Mr. Williams to draft up your agreement and send that to me. Once I sign it, the AG's office will send you both a copy. Dad, you got a question?
Yes. Okay. So, like this week, I've been off of work all week on vacation, and I was supposed to have Jelani this week, and that access was denied. I was just trying to see if I could pick him up today and keep him until the end of the weekend, just so I could spend some time. I didn't spend hardly any time with him this summer, and the time that I specifically took off of work to actually have a vacation with him, take him somewhere, I was denied that. I was trying to see
Okay,
if I
but
could just catch
Dad,
this last tail end.
okay, but Dad, I'll tell you, under the current court order, this week wouldn't have been your week.
Well, I'm assuming that not assuming, but from my understanding that you get a month in the summer, and I didn't. He played baseball. He played travel baseball
Okay,
this summer, so
stop,
I
stop.
pushed that
Okay,
to the side.
so Dad, if you don't come and pick him up at the beginning of your month, then it's going to be up to you and Mom to work something else out. Okay, so
I
next
was I
summer
was
we'll be
denied,
farther.
man.
So we will be much farther along. The court paperwork you'll see, it's going to give you like an April deadline to say the month that you want in the summer. And if you don't say by then it defaults. Okay. So yeah. So let's ask Mom. Mom, could Dad have this weekend?
Jelani, we've already had this discussion. Jelani has baseball today and
Wait,
tomorrow.
hold on. It doesn't matter. Okay. This is Dad's
Yeah.
weekend, is it not? Okay. This is Dad's weekend. Period. So this is Dad's weekend. And so if you guys don't make agreements otherwise, Dad, I would, you may want to.
The father explains that he barely had any time with his child during the summer and had specifically taken time off work for the planned visit. The judge explains how the current summer visitation schedule works and tells him that future visitation must follow the deadlines in the court order. When the judge asks the mother about the upcoming weekend, the judge firmly points out that it is the father's weekend and tells the parents that they need to follow the existing order unless they agree otherwise. This creates the strongest closing moment of the hearing.